The respondent failed to appear before your honor on November 1st of 2023. Current bond is set at $770. This is his third bench warrant. He reports no new employment. Last payment on this docket was a bond forfeiture of $200 made in June of 2023. Friend of the court is requesting that this matter be rescheduled for August 14th, 2024 at 8:00 a.m. before this court.
What was the name again?
Tyler Kipp.
Kip, okay. Mr. Kipp, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your tenants at the next hearing on August 14, 2024 at 8:00 a.m. Are you able to post a bond, sir?
No, sir.
Okay. Well, I note that it is your third bench warrant and you haven't paid in a considerable period, well over a year in this particular matter. So the court's taking that into consideration. And I think I said because you do have a higher rearage as well. What I'm going to do, I am going to reduce your bond in hopes that you could be released. I'm going to set your bond in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
No, sir.
Okay, thank you. You're free to go. Have a good day.
Thank you.
Yes, the respondent failed to appear before your honor for an adjourned bench warrant hearing on July 3rd of 2024. Current bond is set at $8,123. This is the respondent's 10th bench warrant. He reports no new employment. Last payment on this docket was a $2,000 bond forfeiture made in July 2023 of this year. Prior to that, last payment was a $500 bond forfeiture in April of 2024. Friend of the court is requesting that this matter be rescheduled for August 14th, 2024 at 8:45 a.m. before this court.
Thank you. Mr. Watkins, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support. Purpose of this hearing is to set a bond that would assure your attendance at the next hearing on August 14, 2024 at 8:45 a.m. Are you able to post a bond, sir?
Your Honor, you guys just squeezed $2,000 out of me last month. When I got back home, I lost my house and I lost my vehicle and I've been homeless. So I don't have mail, any way to get mail. And I'm on the streets.
Okay, well, last time when you were here and a bond was set, it's just like this time, I'm telling you the hearing is August 14, 2024 at 8:45. The last time I would have told you when that hearing was. So even if you had lost the paperwork, you would have known the date.
It was to be determined at that time.
It was what?
You guys hadn't determined a date yet.
Well, we always determine a date. So
okay.
Just like we're doing today, it's always the same. I don't think and in 11 years, I've never said, well, in a date to be determined. So.
Okay. I could be incorrect. I've got a lot going on.
Okay. Court will note that you do have, this is your 10th bench warrant as well. So the court has some concerns over that. Do note that you did post the bond previously in this matter. I'm going to reduce the bond and I'm going to set the bond in the amount of $1,000. If you can post that, you can be released. Do you have any questions?
Nope.
Okay. Thank you. You're free to go. Have a good day. Okay. Good morning, ma'am. We're going to take some testimony from you, so I'll need to have you raise your right hand, be sworn in, and then we'll proceed.
Okay.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay, ma'am, you can go through the script we provided. However, you don't have to disclose your address if you don't wish.
Okay.
Go ahead.
Okay. Okay, now I can see. Sorry. First, I'm not really technology smart on this thing. Sorry. So I just need to read the script here then?
Yes,
correct?
yes.
Okay. My name is Ashley Bowden. And I just don't wish to give my address out.
That's fine.
And I am the plaintiff of the case. I am married to the defendant on July 16th. I do see here though that it did have a typo of the year. It's 2017, not 2007. That's the only error though that I do see on here. In Battle Creek, Michigan. and I filed the complaint on, on, I just seen it here, this back in February.
That's fine. Just, we don't need the exact day.
Okay. 2024. I've lived in Michigan for 180 days, in Calhoun County for 10 days, prior to filing. When I filed my complaint for divorce, all of the statements were true. All the statements in my complaint for divorce are still true. There has been a breakdown of the marriage relationship such that the objects of
Matrimony.
have been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. I do not believe there is any possibility of reconciliation. Is that correct?
Reconciliation, correct.
Okay. I am not currently pregnant. The defendant and I have one minor child together, and she's 7 years old. I have read all of the terms of the proposed judgment of divorce, and I agree with them. And I ask that the court grant an absolute, I believe that's correct, the judgment of divorce. Thank you, Your Honor.
Thank you. Court will find that the testimony does establish a statutory basis. There has been a showing there's been a breakdown of the marital relationship. File does appear to be in order. We do have front of the court approval. Time is run. Ma'am, I'm looking at the proposed judgment and the UCSO. It does have what purports to be your husband's signature. Do you recognize that as his signature?
Yes.
Okay. The court will sign the judgment of divorce, which means, ma'am, you are divorced. Best of luck to you. I hope everything works out for you. And you're free to go. Have a wonderful day.
Thank you very much. I appreciate it.
We're ready for your case. Let's move on to our next case here in the list. Ma'am. Yes,
Hello?
Ms. Schlesinger, can you hear us now?
Yes,
Okay.
I can't see. Oh, I can see you now. Okay.
Okay.
Good morning to both of you. This is the time and place set for the scheduling conference, and the scheduling conference is where the court puts in place various time deadlines as well as other processes so the case will proceed in an orderly fashion. I go to the plaintiff first, and then I'll go to you, ma'am. So, Mr. Plessinger, what issues do you believe to be in dispute in your case?
None.
None? You think you have resolution of everything? Is that accurate?
Yep.
Ms. Plessinger, is that your understanding?
Yes.
Oh, okay. Now, what I'm going to do is I'm not going to put in place a scheduling order at this time. And the reason I'm not is because that would initiate the mediation process, and there's a cost associated with that because the mediator would be an attorney mediator and you'd have to pay for that. So obviously you don't want to do that if you have resolution in this case. Mr. Plessinger, because you are the plaintiff, you're responsible for preparing the judgment of divorce, uniform child support order, and something called a judgment information form, those three documents. Once you get those prepared, you can submit those to the friend of the court for their approval. And when they've approved them, then submit them to Ms. Plessinger for her approval. And once you have the approvals, then we just have to wait for the time frame to run, and then we'll be able to conclude the case. Do you have any questions, sir?
What were them three documents again?
Judgment of divorce, a uniform child support order, and a judgment information form.
All right.
And if you've been using a service such as MichiganLegalHelp.org, they have all those documents. They have all those documents online.
Yes, sir. I do know exactly what you're talking about.
Okay. Well, I will let you go. What we'll do is we'll reschedule this. We'll reset a status conference in about 60 days. That way we can keep track of it because, as you can imagine, we have thousands of cases and we can't keep track of them if we don't keep them on a schedule. So we'll see you back in about 60 days and be able to see if you're progressing and what's happening and if there are any issues. Okay?
Yep.
Okay. We'll let you both go. Have a good day.
Thank you very much.
All right, thank you.
Good morning to both of you. This is the time and place set for the scheduling conference. In this matter, a scheduling conference is where we put in place various time deadlines as well as other processes so that the case would proceed in an orderly fashion. I will go to the plaintiff first, and then I'll go to you, Miss Eddy. And I guess, Mr. Eddy, I'll ask you, what issues do you believe are in dispute in the case?
In dispute of the case, sir?
Yeah, what are the two of you arguing about or can't agree upon?
Well, Your Honor, there hasn't really been a lot. I believe Lindsay and I have been on the same page about everything, and there hasn't really been too big of arguments. Yeah, I mean, we're on the same page with custody and ownership of the asset that we own together, the house mainly. And we've separated our finances and each have individual. The biggest concern that I have is child support and the correct amount of money being able for me to be able to pay Lindsay with child support.
Okay. Well, sir, you're going to be, as you're the plaintiff, you're going to be responsible for preparing the judgment of divorce, uniform child support order, and the judgment information form. So if you get onto a service, if you're using like MichiganLegalHelp.org, if you get on that, you can plug in your incomes and that will tell you what the amount of support is. So it's a real simple process. Miss Eddy, do you believe that there are any disputes in your case?
I don't think so. Since we filed the paperwork, we did change over. I was gonna keep the house, but we changed and he's moved back into the house now. But it was not a dispute at all, just a decision we made.
Okay. Well, what I'm going to do is I'm not going to put in place a scheduling order at this time. And the reason I'm not, because that would initiate the mediation process. And that's a process whereby an attorney mediator would meet with you to try to resolve issues. There's an expense associated with that. And if you are able to resolve them, you don't need to incur that expense if you're able to take care of it yourself. So what we'll do is simply at this particular time is I won't do that. I'll let you, Mr. Eddy, work on preparing those proposed judgment, the uniform child support order and the judgment information form. And once you've prepared those, you can submit those to Miss Eddy, and if she approves them, then you submit them to the front of the court and they will approve them. And once we have that, then we just have to wait for the time frame to run and we can complete the case at that time. So what we'll do though is I will reset this for about 60 days out. That way we can check and see that you're on track and that something's happening in the case, et cetera. So, but get those documents prepared and get those to Miss Eddy into the front of the court. And as long as everybody approves them, then at the time we come back for the status conference, just let us know that, and then we'll just wait for the time frame and be able to conclude the matter.
Yes,
okay,
sir.
Okay, you're free to go. Have a good day.
Thank you. You too.
Good morning to both of you. This matter is before the court on basically a scheduling conference, and the scheduling conference is whereby we put in place various dates so that the case would proceed in an orderly fashion, also initiate, again, different processes so that the case would proceed. I'll go to the plaintiff first, and then I'll go to you, Ms. Kirschmeyer. So, Mr. Jones, what issues do you believe are in dispute in your case?
I don't agree with the mediation and like 50-50 custody and 50-50 legal and 50-50 legal and sole custody of them.
Okay, so custody is in dispute, correct?
Yeah, yes, sir.
Okay, I'll put custody, parenting time, and support because they all are interrelated.
Okay.
Is that your understanding, Ms. Kirschmeyer?
It is.
Okay. Do you anticipate any discovery in this matter? And discovery is the process whereby you acquire information from the other side so that, again, you can get information if you don't have it. Mr. Jones, do you anticipate any discovery?
No.
Okay, Ms. Kirschmeyer, how about you?
No.
Okay, well, the case is pretty new, so what I'll do is I will give you a October 1 deadline for discovery. That way, if you do change your mind or you think you need something, you can do that, but you'll have to do it by October 1. That will set October as the mediation month. Court will send the matter to mediation. I'll ask Mr. Jones, is there any mediator that you suggest or recommend in this matter?
No.
Ms. Kirschmeyer, how about you?
I would like the mediator we already held mediation with, which is,
What?
I would like the mediator we already had a mediation meeting with.
Did you work with somebody at the front of the court for mediation?
We worked with Kristen Arnett. She was on the list provided when I was served the court papers.
Okay. Was she not? So you already went through mediation, correct?
Correct.
Okay.
Both
And
parties
apparently you weren't able to come to an agreement.
both parties signed the mediation agreement, and he is now disagreeing with what he signed.
Okay. Well, we don't have that in the file yet, so what happens, I will look at that. Sir, if in fact there was a mediation agreement and you signed it, you're going to be bound by that, sir.
Okay.
So we'll have to look and see. I'm not going to, being that you've been already in mediation, I'm not going to send you to mediation again there, unless if the two of you choose to, or you want to go to mediation, then you always have a right to do that. But at this point, if you have an agreement, then there's no reason to send it back to mediation. So what I'm going to do is I'm going to reset this for a status conference in about 30 days, maybe 45 days. And what we can do is I'll be able to get a hold of the mediation agreement and be able to review that and be, prepared to proceed with the case at that time depending on what the mediation says. Okay. Anything else that you have, Mr. Jones?
Do not.
Okay, Ms. Kirschmeyer, anything you have?
No, sir.
Okay, I'll let you both go then, and have a good day, and we'll see you back in about maybe 45 days.
You as well. Thank you.
Thank you.
Julian. Right.
This is time and place set for a status conference in this case. I'll go to you first, Ms. Kreider. Enlighten me, what's happening in the case or not happening?
We had just had the front of the court approve all the papers that I had submitted. So now we're just waiting for Elijah to receive the papers and sign them and send them back in.
Okay.
We should preserve the proofs, Judge. We haven't done that in this.
Yeah. Ma'am, what we're going to do is I'm going to take some testimony from you. That way, again, that'll keep you from having to come back again. I don't know if you've gotten the divorce script that we usually send out, because being it wasn't set for a pro-con, you may not have that. Is that accurate?
I'm not too certain what that is, so I don't think
She wouldn't have it as a status.
Okay. What I'm going to have you do is raise your right hand, be sworn in, then we'll proceed. Ms. Kreider, you filed a complaint for divorce, seeking a divorce from the defendant in this particular matter. And at the time that you signed that complaint and filed it, had you been a resident of Calhoun County for more than 10 days?
Yes.
And had you been a resident of the state of Michigan for more than 180 days?
Yes.
Were all of the allegations in the complaint true at the time that you signed it?
Yes.
Are they still true?
Yes.
Are you currently pregnant?
No.
You state in the complaint that there has been a breakdown of the marital relationship to the extent the object of matrimony had been destroyed, and there remains no reasonable likelihood that the marriage can be preserved. Is that a correct statement?
Yes.
Is there any chance that you and the defendant could reconcile and live together as husband and wife?
No.
Court will find that the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will preserve the proofs in this matter pending receipt of the approval. Court notes the front of the court has approved it. We're simply waiting approval from the defendant. And what time we receive that, ma'am, you can send that paperwork in, and provided the 180 days has expired, we'll be able to enter it at that time. Do you have any questions, ma'am?
No, I do not. Thank you.
Okay. Thank you. You're free to go. Have a good day and wish you all the best.
Thank you. Have a good day.
Vanessa Rojas versus Trinity Garrett. Prosecutor's Office, Attorney Jimmy Storton, and Kevin Sackwriter for the public defender on behalf of the defendant.
Good morning to everyone. This matter is before the court for the arraignment of Mr. Garrett in this particular matter. Mr. Garrett, in this particular case, I'm going to advise you of various rights that you have. You have the right to be advised of the alleged violation. In this case, the allegations are that on August 7, 2024, that you did in fact violate the personal protective order issued by Judge Yost Johnson on February 1, 2024, which prohibited you from entering upon the premises where the petitioner, Ms. Rojas, lives, or by confronting her on private property in a public place, or remaining on property where she occupied, owned, or leased, and that in fact you did likewise assault her on that particular date. You have a right to contest the charges. You have a right to an attorney. The court has appointed Mr. Sackwriter to represent you for today's hearing, but you have a right to have attorney in this matter in the event that the court believes it may impose jail time in this particular case. You have a right to remain silent and not have that silence used against you. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to confront witnesses. You have the right to call witnesses. If you cannot get those witnesses to appear, you have a right to ask that the court would compel those witnesses to appear. In this matter, Mr. Sackwriter, how is your client going to plead?
Not guilty, Your Honor.
Okay. Court will accept a not guilty plea on behalf of Mr. Garrett in this matter. Court notes Mr. Jordan had made a request for an adjournment in this particular matter. Mr. Sackwriter, do you wish to speak to the issue of the adjournment?
Yes, thank you, Your Honor. We would ask that my client be released on a $0 conditional no contact bond pending the hearing in this matter. The client has entered a not guilty plea. My client is employed at the Gun Lake Casino currently. He does share 2 children with the petitioner in this matter. However, he told me that he will not be staying with her pending the hearing at a later date. For all those reasons, we'd ask for his release. Okay.
Mr. Jordan, you wish to speak to the issue of bond?
Your Honor, the people will be requesting a $500 cash bond. Defendant was apprehended by police at the petitioner's home in direct violation of the PPO, and he also is facing criminal charges. Our office received a criminal complaint against him, which is being reviewed this morning as well in regard to an assault that occurred out of the contact with the police at the petitioner's home. So for her protection, protection of the public, we're requesting a $500 cash bond in this matter.
Okay. Mr. Sackwriter, so address the issue, if you would, on the request for the adjournment as well.
We would have no objections to the statutory adjournment in order to get witnesses and evidence in this matter.
Okay, thank you. Well, in this matter, the court has reviewed the file. I've reviewed the police report as well. And it does identify in this case, and obviously there is a personal protective order. Mr. Garrett, you do have to comply with that order, notwithstanding anything that might have happened. The court does note that in the police report that the petitioner stated to the police that she had invited Mr. Garrett over to stay at the residence. And as a result, obviously the altercation occurred after that time when he was at the residence. As a result, what the court is going to do is the court is going to set a cash bond in this matter in the amount of $100. So, sir, you're going to have to post the $100 to be released. And then the court will set the hearing on this matter for August 30, 2024 at 9:00 a.m. before Judge Yost Johnson. Anything else, Mr. Jordan?
No, we thank the court.
Mr. Sackwriter?
Nothing further.
Okay, thank you. That will be the order of the court. You're free to go. Have a good day. Mr. LaForge, you're before the court today for a civil contempt hearing as a result of your failure to pay child support and or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges, sir?
I do, sir.
Court has appointed Ms. Huffman to represent you in this matter. Have you had sufficient time to speak to Ms. Huffman in preparation for this proceeding?
I have, sir.
And Ms. Huffman, are you ready to proceed?
I am, thank you.
Okay. Mr. LaForge, I'm going to have you and Ms. Paul raise your right hands. We'll have you sworn in, then we'll take some testimony.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
I do.
Go ahead, Ms. Huff.
Thank you. We're here today for a bench warrant hearing for docket number 2016, Joshua LaForge, after he failed to appear at a bench warrant hearing before your honor on May 1st of 2024. The respondent's total monthly obligation is $902. This comes from $599 for current support, the guideline amount of $299.50 towards arrears, and $3.50 per month for service and processing fees. The last voluntary payment made on this case was $100 in February of 2024. He did post a $500 bond in May of 2024 that was forfeited and applied to this case as well. This is his second show cause. He's had 6 bench warrants and no contempt findings. I've monitored his compliance for the last 6 months at the rate of $902. He should have paid $5,412, and he's only paid $600, including that bond forfeiture. Total arrears on this docket are $39,133.99 as of July 31st, 2024. Friend of the court would like your honor to be aware that the respondent has failed to participate in the Michigan Works GEMS program after being referred multiple times. He does have the ability to work and pay on this obligation. He stated to me that he does do odd jobs and works on cars for money. Joshua did book into Calhoun County Jail on July 22nd, 2024 and has credit for 17 days served.
Okay, thank you. Ms. Huffman, do you contest or dispute any statements made by Ms. Stolf?
I do not, thank you.
Do you have any questions for Ms. Stolf?
No.
Okay, any proofs, Ms. Huffman?
Yes, so I would call Mr. LaForge.
Okay, go ahead.
Thank you. Mr. LaForge, you heard everything Ms. Hoff testified to, is that correct?
Yes, ma'am.
Okay, and you believe all of that information to be correct?
Yes, ma'am.
Okay, so she indicated that you had failed to participate in the LEAP program twice recently. Why did you fail to participate in that program?
It was a matter of I didn't have sufficient housing. I was bouncing between places and I missed the packets in the mail. I did want to sign up for those programs. I did want to do it. I want to work. I don't want to not work, but I missed the packets, and by the time I got them, it was far too late, and it was too late.
Okay, if you were to pick up the packet or be given the packet now, would you fill out whatever you need to and participate in that program?
I would fill it out before I went home. Absolutely.
Okay, and then you indicated that you want to work, that you don't want to be not working. Why are you not working?
The biggest reason is the bench warrants. They prevent me from keeping employment.
Okay, and you had indicated to me earlier that you were working at Lakeview Auto Body at some point, is that correct?
Yes, ma'am.
And that you had been there for 8 years?
Yes, ma'am.
And what happened to make you lose that job?
Well, the bench warrants, the gentleman's wife was a Battle Creek police officer, and it was a conflict of interest. I couldn't keep the employment with bench warrants.
Okay, and what were the bench warrants for? Just the support?
Yes, ma'am.
Okay. And so after you lost that job, were you able to, I guess, when did you lose that job?
That job I lost in 2020.
In 2020?
2019, I'm sorry.
Okay. And then since 2019, have you had any other employment?
I've worked part-time at Kai's Auto Body, but other than that, no, ma'am.
Okay. And you state it's been because you've had warrants?
Absolutely.
Has there been any other reason why?
No, ma'am.
Did you have an accident in 2021 or something that?
I did. I had a trailer smash my head and give me a traumatic brain injury, ma'am.
Okay. And do you still suffer from that injury?
Every day.
What is
affected my reading, my writing, my relationship abilities? It affected much of my life.
Do you seek treatment for that now, or is there anybody that you I guess, are you seeing a doctor for any of those reasons?
No, ma'am.
Is it because there's nothing else that can be done, or you just haven't?
I don't have insurance.
You don't have what?
Insurance currently.
Okay. Would you be able to get proof of that injury and the resulting side effects that you have? Would you be able to get proof for the caseworker in the court?
Well, absolutely. Once I get insurance, yes.
Would you be able to get copies of the I'm assuming you got treatment in 2021 for those injuries?
Yes, ma'am, in the emergency room here in town.
Okay. Could you get copies of that information too?
Absolutely. Yes.
Okay. If the court were to let you out of jail today, what would you do?
I would catch up with my father south of town. He has a body shop at his property, and if I have my warrants taken care of, he'll let me work out there. But if I have warrants, he won't let me work. So if I leave today with my warrants squared up, I can go to work by first of next week.
Okay. Then do you know how much you would be making?
I don't. It'd be anywhere from a few hundred to $1,000 a week, depending on the week.
Okay. And so if you started next week, that would be Friday would be the 16th. Would you be able to make a payment by the 16th?
Yes, ma'am.
And you indicated to me that you could make $100 on that day at a minimum. Is that true?
Yes, ma'am.
Okay. But you would make more than 100 if you could. You
I
just
could.
aren't sure what you'd be making.
Absolutely.
Okay. And then it also indicates on your court prep sheet that you have not returned your support review packet nor filed a parenting time motion. What is the reason that you've not done those things?
As I told you, traumatic brain injury, I struggle with paperwork very, very much. So once I get back to work, I can get an attorney hired and then get these motions filled out and sent in.
Okay. Would you be willing to contact legal aid and ask them that since you do have a disability or an injury and that you need help filling out paperwork, would you contact them to see if they would be able to help you?
Absolutely, especially with the warrants being taken care of.
And you would file both the motion to amend or change the parenting time and the support?
Yes, ma'am. The parenting time is the biggest one, but absolutely with the support as well.
Okay. And the issue with the parenting time is that, well, scratch that. So have you applied for jobs or tried to work in the past several years?
I've applied to several jobs, but when they run a background check and see the warrants, nobody will hire you.
Okay, where did you apply?
I've applied to I Stanley, I've applied to Nip and Denso, I've applied to Post. I was hired into Kellogg's or accepted into Kellogg's until I didn't pass the background check. I've applied to several places. Adient was another place I applied at.
I'm sorry, I missed that.
Adient, Tenneco. I applied to both of those places, and again, without passing the background, I can't get employment.
Okay, so then you state it's because of the bench warrant. Are you in? Is it a constant bench warrant that's on you?
Because of my failures to appear, it's a vicious cycle, man.
And what are the reasons for your failure to appear?
Again, without having steady housing or steady transportation, just making it down and remembering to get into the court dates, it can be so overwhelming. It's just sometimes easier to give up.
Okay, so I'm going to kind of summarize what you've stated to me and you tell me if what's the case. You had a job for 8 years, but you had a bench warrant and lost that job. And since then, everything has just gone downhill for you.
Yes, ma'am.
Okay, and you believe that if you could get a job, that things would go back to the way they were at one point?
I know they would. I'm a good worker.
Okay, and you think you could get that job even with the brain injury that you were discussing earlier?
I would sure try like hell.
Okay, I have no further questions. Thank you.
Thank you. So the forge, you had stated to Ms. Toth that you had worked some odd jobs. Is that the part-time that you talked about working at Kai's?
Yes, sir.
And when you work part-time, how much would you make on an average month?
It's so hard to predict that, sir, because the ebb and flow of the work. For example, wintertime, you can make some really good money in the wintertime due to the bad roads, but in the summertime, hell, you may go 3 weeks and not make but a couple bucks. It's so hard to give you an average monthly dollar amount.
Well, give me an average monthly dollar amount in the winter, let's say.
Say part-time in the winter, at least 1,000 to 2,000. Yeah, that's fair to say.
How about in the summer?
500 to 1,000.
Any other odd jobs that you worked other than at Kai's?
No, sir.
You understand, sir, it's to your best interest to get the paperwork in to have the support reviewed in this particular matter. You understand that?
I do, Your Honor.
Okay.
Now, when you say paperwork, do you mean proof of income or proof of
No,
injuries?
no. If you're filing for a support review, you have to file that packet requesting the review first, and then you'll have to provide income information. But you know, it's incumbent upon you if you want to review it to file something so the court knows that you want to review it, because otherwise we can't guess.
I understand, sir.
Anything else that you'd like to tell me, sir?
I'm not a bad person. I want to get out there and get back to work. I want to see my daughter. That's the biggest thing I want is to be able to get a relationship with my daughter again. She was such a daddy's girl. She used to love coming down to the shop and helping me fix things. And it breaks my heart not seeing her. And I want that so much. It's been almost 8 years and That's the biggest thing that I want out of all this is a relationship with her again.
Anything else?
No, sir.
Okay. Well, in this matter, the court will make the following finding that Mr. LaForge obviously has a considerable support overage in excess of $39,000. So that is something that's not obviously came in just on an isolated basis, that there is a history of non-payment of the support. Some of it could be the fact that he's paying $902 a month, but he hasn't been obviously hasn't filed the paperwork. He needs to have that reviewed to see if it's accurate or appropriate. In this case, that he lost his full-time employment, for which he made good money back in 2019. Because, as he said, because of a bench warrant, but he hasn't taken action to clear up those bench warrants. Now it would be in 5 years, notwithstanding the fact that they've kept him from getting employment. He has worked part-time at Kai's Auto Body. Says in the winter he'll make between $1,000 to $3,000 per month. In the summer, $500 to $1,000. Notwithstanding that, he has not paid any amount towards his support overage other than maybe some isolated payments and the bond payments as well. That he has failed to participate in the GEMS program, which would allow him to assist him in getting employment. He claims that because of housing, he's missed the packets, etc. Notwithstanding that, he knew about the GEMS program. He could have called. He could have taken other action to again participate, and he has repeatedly failed to do so, as he has failed to have a support review in this matter. Court will find that he has failed or refused to comply with the orders of the court. He has not done so in good faith, and as a result, or for any reason that the court could see a legitimate reason, as a result, the court will find him in contempt of court. Anything before sentencing, Ms. Huffman?
I would ask that the court allow him to have time served at this point. He does have, I believe, 17 days was the testimony. I would ask for the court to consider that, or a purge amount, a low purge amount. He did indicate if he could get out, he would have a job, at least working with his father at that auto body shop. And by the 16th, he would be getting a paycheck from that job. I would ask the court to give him the opportunity to be able to prove whether or not he will do that. And if he's not doing that, then the court could always assess more jail time at that time. But I would ask for the consideration now to give him that opportunity. Thank you.
Thank you. What the court's going to do is the court could sentence you up to 45 days. Mr. LaForge, I'm not going to do that. I am going to sentence you to 30 days in jail with credit for 17 days served. The court would allow you to purge yourself of contempt by paying the sum of $1,000. If you're able to pay that, you'd be able to be released. Do you have any questions, sir?
No, sir.
Okay, thank you. You're free to go. Have a good day.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Have a good one.
Okay. Mr. Stewart, in this matter, you're before the court charged with civil contempt of court duty or failure to pay child support and or related expenses. On the first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. Do you understand the charges?
Yes.
Court will advise you have a right to an attorney. The court would appoint an attorney to represent you should you desire an attorney. It's my understanding you wish to proceed without an attorney. Is that correct?
Yes.
Are you doing so freely and voluntarily?
Yes.
Has anyone threatened you, coerced you, used any undue influence, pressured you, or promised you anything to get you to appear without an attorney?
No.
Court will find that Mr. Stewart does freely and voluntarily waive his right to an attorney. Mr. Stewart, we're going to take some testimony from you, Ms. Mouton. We're going to have you raise your right hand, be sworn in, then we'll proceed.
Your Honor.
Yes.
This hearing isn't for the contempt finding. Mr. Stewart is actually, he has gained employment and income withholding is established. So front of the court was going to request a dismissal.
Oh.
The matter before the court is the bond that he posted.
Ms. Mouton, you could have interrupted me. And
Well, you were on a roll. Sorry.
okay, thank you. Okay, Mr. Stewart, front of the court has recommended that, again, we cancel the bond, basically dismiss the case. Yeah, I assume you don't have any opposition to that.
Your Honor.
No.
What, Mr.
So he posted a bond in the amount of $873, and he is requesting that the bond be refunded back to him and not forfeited towards his arrears.
Okay.
Yeah. So I just had a custody hearing on Monday for the girls, and basically Justina didn't even show up to the hearing. I have had custody of my daughters for the last 3 years while paying child support, getting no help from Justina at all. That's why I requested, could I get that money back and maybe file a motion to lower the rearages or have them dismissed, because I've been taking care of the kids solely by myself for the last 2 to 3 years.
Okay. Ms. Mouton, what you're recommending in this matter regarding the bond?
Your Honor, this docket is arrears only, but there is Mr. Stewart did file a motion for custody, and there's also a support review and a rev mod in the process. We do have income withholding in place, and it's coming in around just under $600 a month. So front of the court would not be opposed to refunding the bond to Mr. Stewart.
Okay. Mr. Stewart, you've heard Ms. Mouton
yes.
Make a recommendation that we would in fact refund the bond to you and not basically not forfeit it. So the court will follow the recommendation, so they'll be able to refund the money to you in this matter. Anything else, Ms. Mouton?
No, Your Honor, not on this docket.
Okay. Mr. Stewart, you're free to go. Have a good day.
Thank you. Question, do I have to come in and sign anything to or does it be mailed out to me? I'm not quite familiar how this process works.
Okay, quite frankly, I'm not either, because we rarely, if ever, refund a bond. So, Ms. Bhutan, is he going to have to sign anything, or is it?
He will not have to sign anything. It will be mailed back to you.
Okay.
Okay.
It should be mailed back to the address that you have on record, sir.
Okay. Thank you. Thank you.
Thank you. Have a good day. Anything else, Ms. Bhutan, besides your other cases?
Nope, not on that docket.
Okay. Thank goodness. I didn't think we'd get that one done.
I'm sorry, you were on a roll. I was trying to stop you, but you were just going today.
Okay.
Okay. Are we ready for my other case?
Yep, go ahead.
Did Mr. Sisson come back?
No, he didn't.
Okay.
He was here for a while, but then he dropped out when I sent you that message.
Okay, so in the matter of Felton Brim versus Amarian Sisson, Dr. Sisson was ordered to appear this morning for an adjourned compliance hearing. Front of the court adjourned this matter to allow him to file a motion to modify his obligation. He has not filed a motion and he has apparently absconded. So front of the court would request that a bench warrant be issued and that bond be set pursuant to statute.
What was the individual's name?
Amarian Sisson, Sisson.
Okay. Court would enter a bench warrant for Mr. Sisson as a result of his failure to appear on today's date. At this hearing, the court would set his bond in the amount of 25% of the outstanding arrears for $500, whichever is greater.
Thank you, Your Honor. And then I just have some referee bench warrant
The
requests.
defendant is not here. Attorney Mackinson for the front of the court.
Okay. Good afternoon to both of you.
Good afternoon.
This matter is set for the court for a evidentiary hearing on the plaintiff's motion to determine child born out of wedlock. In this matter, I guess, Ms. Crawford, do you have any opening statement to make, or just proceed to take testimony?
Just proceed. Yeah.
Okay. Ma'am, what we'll do is we'll have you raise your right hand, and then we'll swear you in, and then we'll proceed.
Okay.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay. Mr. Magnuson, would you like to conduct the examination?
Sure, Your Honor.
Okay, go ahead.
Ma'am, would you state your name for the record?
Yes, Brittany Ann Crawford.
And you are the mother of the child in this case, is that correct?
Yes.
And you are indicating that Mr. Crawford is not the biological father of this child?
Correct.
And what is the child's name? And you and Mr. Crawford are currently married, correct?
We got divorced September 20th of 2023.
Okay.
The case is just under my married name.
Okay. And Zariah was born during your marriage, correct?
Right after we got divorced.
Okay. When were you divorced?
September 20th of 2023. And the Zariah was born 4th.
Okay. Now, during the time of conception, were you having sexual relations with Mr. Crawford?
No.
When was the last time that you and he had sexual relations?
The last time me and Mr. Crawford had sexual relationships was of May of 2021.
So in your mind, there's no possibility that he could be the father of that child, correct?
Definitely not. There's no way.
Okay. And who is the biological father?
His name is Marquez Jones.
And does Mr. Jones have a relationship with the child? Does he spend time with the child?
Mr. Jones is currently incarcerated at the Calhoun County Jail. But I've brought the baby up to him every Tuesday since she's been born.
Okay. And you'd be willing to cooperate in the establishment of paternity regarding Mr. Jones?
Yes. I've been open with him about this, and I told him about it, and he said he was wondering how he would get a DNA test, and he's willing to and wants to.
Okay. I have nothing further, Your Honor.
Okay. Anything else you'd like to tell me, ma'am?
No, that's it.
Okay. Has Mr. Jones been incarcerated since the child was born?
Yes, he's been incarcerated since, I want to say, the end of September, early October of 2023.
Okay. Anything else you have, Mr. Magnuson?
No, Your Honor, I just asked the court to find that there is, I believe, clear and convincing evidence that Mr. Crawford is not the father, the biological father of this child. Just for the record and for informational purposes, my office is involved because we have a referral from the Department of Human Services to proceed against Mr. Crawford. And obviously, if this relief is granted, that would eliminate the need for that. And we would take all steps to legitimize the child regarding Mr. Jones.
Okay, thank you. Well, in this matter, the court's heard the testimony given by petitioner today. I've also reviewed the file. I note that in the file, she acknowledges that the last sexual relation she had with the defendant was back in May 18 of 2021. The child was born in April of 2024, so approximately 3 years later, and clearly he has no opportunity to be the father, no matter how long the gestation process would be in this particular matter. So the court will determine that Zariah will be determined to be a child born out of wedlock, not issue of this marriage, and that the defendant is not the biological father of Zariah. The court will prepare and submit that order. Ma'am, that'll be ready probably sometime tomorrow if you needed to get that for some reason. And at this point, there's nothing else. You're free to go. Have a good day.
Thank you so much.
Thank you.
All right. And
Thank you.
For the
Mr.
defendant?
Magnuson will keep you in.
Yeah, just, I mean, for.
I am for defendant. Yes, that's correct.
And is that your name, Kimberly Mano what?
That is correct, sir. Yes.
Ma'am, how are you involved in this action?
Hi. Yes, Christian Jones is my brother. I'm his legal guardian to the state of Indiana.
Well, I still don't have the plaintiff anyway, so.
Oh, right. I understand. This has been kind of ongoing, so I'm very familiar. But I just wanted to show up and just because of the simple fact that we did have a paternity test done and we did get the results. So I just want to make sure that we're compliant as far as what needs to take place going forward. So I thought it was necessary for us to show up.
Well, Judge, we don't have the plaintiff, so.
It wasn't filed by plaintiff, though. It was filed by FOC.
Right. I mean, procedurally, I think the court ordered genetic testing and we received the results. Essentially, one child listed in the complaint was determined to be the biological child of Mr. Jones. The other child was excluded, so we prepared a motion and set it for a hearing, and then the court set it for a evidentiary hearing.
Okay, then let me call the case. So this is Shalea Riley or just Christian Jones?
Court, we've already acknowledged Mr. Magnuson is present on behalf of the front of the court in this particular case. And we don't have the woman's name, what is it?
Kimberly Manawat.
Kimberly Manawat is here as the legal guardian, I guess, of the defendant in this particular matter. Mr. Magnuson, any thoughts on proceeding without either of the parties present?
I would not be opposed to that, Your Honor. Obviously, it's the court's decision, but however, the fact that we do have, as some background, the court did order genetic testing in this case. That was ordered on April 24th of this year. A judgment had entered back in January regarding two children, Nasaria and Nazaria. The genetic testing results dated May 28th of this year indicate that Nasaria is Mr. Jones's biological child. However, Nazaria is not. That child was excluded. I believe, based on the admission of the genetic testing results as evidence in this case, that could present the court with clear and convincing evidence that Nazaria is not Mr. Jones's child, that he is not the biological father. And I think that would be enough to get us there.
Okay. Well, the court notes that we do not have, obviously, the parties here. Again, I think that based upon review of the file, that there is sufficient evidence to proceed at this time, so we will do that. The court does note, as stated by Mr. Magnuson, that the court did enter order for genetic testing back on April 22nd, 2024. The genetic testing occurred on May 28, 2024 of, again, the parties and the minor children in this particular matter. So I guess at this point, Mr. Magnuson, I'll let you proceed if you want to introduce the genetic test reports by DNA Diagnostic Center.
Yes, Your Honor, I'd be moving for the admission of that document. It is, as the court's indicated, dated May 28th of 2024. And for the record, it does indicate a probability of paternity for Nasaria of 99.99+%. As for Nazaria, that is 0%. Mr. Jones is excluded per the testing as the biological father of that child.
Okay. Ma'am, as a legal representative, I know you're not the attorney and you obviously can't, again, speak on that behalf. Is there anything you wanted to say in this matter?
I'm speaking on behalf of my brother. He's an incapacitated adult. And I have spoke on behalf on many occasions. So when I speak, it's because I knowingly and have a very personal bond with my brother. And I am the one that kind of set forth for him to go ahead and pursue seeing which, if either of these children were his, because he wants a relationship more than just, through the course. He wants to be a father with my help. I do a lot of help with going to travel to get the children and things like that. So a lot of things that we were doing for both children, it's emotional to hear the facts because we've been doing that for a very long time for both of the children. So it was very heartbreaking to find out one of them were, but for the one that is his biological child, we would just like a little bit more. He's not on the birth certificate. We would love for him to have some type of rights, more so of just the mother, saying when and where, things can happen.
Well, that's fine. What's going to happen? All this is determined if the child is born out of wedlock and not issue of this marriage. So all that other stuff is fine, but you're going to have to file the appropriate complaint or motion to get that matter before the court. We're not going to do that today. Okay. Well, do you have any problem to the admission of the genetic test results?
No, not at all.
Court will admit the genetic test results dated May 28, 2024, and as a result, the court will grant that particular order determining that Nazaria is not issue of this marriage, not again a child born out of wedlock, and in fact not the biological parent, not the biological child of the defendant in this matter. Anything else, Mr. Magnuson?
No, thank you, Your Honor.
Okay. Ma'am, do you have anything else?
No.
Okay.
Thank you very much.
You're free to go. Have a good day, and that will conclude this matter.
Thank you, sir. Take care.
Thank you, Your Honor.
All right. Will you do that under the 7-day judgment? Attorney Thomas Schaefer for the plaintiff and Attorney Allison Green McCord for the defendant.
Good afternoon to everyone.
Good afternoon, Judge.
Court will note that this is a continuation of the evidentiary hearing commenced initially on April 30, 2024, continued on June 7, 2024. And then at that time, when I look back through my notes, I note that my recollection is, at least my notes show, that we had concluded the proofs at that time, and that simply at that time we took a recess as the court wanted to hear from the counselor. And I guess I'll ask Mr. Schaefer, is that accurate?
That's consistent with my notes, Your Honor.
Okay. And Ms. Greenlee-Clore, is that your understanding as well?
Correct. That is my understanding. Mr. Schaefer's office was to have subpoenaed the counselor.
Okay.
And we did, Your Honor.
And is the counselor present?
I don't know. I should.
I have a Christie in the waiting room. Is that the one?
That is the one.
Go ahead, Mr. Schaefer.
Thank you, Your Honor. Ms. Briggs, would you tell us what your profession is?
I'm a clinical social worker.
And how long have you been doing that sort of work?
What, 20 to 24 years?
That's almost a permanent job, 24 years.
Yes,
and,
yes.
And as a professional social worker, what type of work do you do?
Currently, I'm mostly working with adolescents to adults who suffer with anxiety or depression.
And what is your educational background?
I have a bachelor's degree from Central Michigan University and my master's through Grand Valley State University. And then you have to, every 3 years, get your license renewed through the state of Michigan and do certain requirements there.
Are you familiar with Caden, the child of Stephanie Bailey and William Roth?
Yes.
And have you been counseling with him?
Yes.
And when did that counseling begin?
I would have to double check my notes for the exact date, but I think it's sometime in February or January of this year. I can look it up quickly.
Okay, if you would, please.
Yep. I was contacted the end of December and our first meeting was January 8th of this year.
And how many times have you counseled with Caden?
Looks like we've had 23 sessions.
And have you had any sessions with Caden and his father, William?
Yes, I have.
And how many have you had?
I believe 2 or 3.
And can you tell us the last one that you had with Caden and his father?
Yes, that was recent. Yeah, I guess it's July 29th, Monday.
All right. And are these sessions in person or on Zoom, or how are they conducted?
We've conducted them both ways. The initial appointments were in person. The ones I've held with Dad and Mom are also in person. And then when it's just me and Caden, we've been doing it over Zoom.
All right. And what sort of issues have you been dealing with Caden?
Caden was very anxious about, I guess, the custody situation between Mom and Dad. And having to return to Dad's home, which is where I think legally he is supposed to be located.
All right. And did you have discussion with Caden concerning going back with his dad?
Yes.
And what was Caden's position in that regard?
He did not want to live at Dad's house.
And did you make effort to bring the relationship of Caden and his dad so it was more compatible and they would get along better?
Yes, but when Caden is with his dad in my setting, he said he feels very safe, and so they're very amicable. But I talked to Caden about things like if he returns to Dad's house, what he could do to prevent some of his complaints. And then I've also talked with William in the 2 sessions we had together with Caden about some of the issues that Caden had brought up to me and what they could do differently.
And what were those issues, and what was discussed as doing things differently?
The 2 major ones were chores and the jobs and responsibilities around the house. And then Caden had referred to being abused. And when I asked him more specifics on that, it seemed like it was things where horseplay, I would consider it like Caden would say they were wrestling, but then it got out of control and Dad got mad and then he would say he was hurt. So his term when he used abuse with me typically meant some type of physical contact that Caden didn't want.
And do you believe that you made any progress on those issues that you have told us about, the chores, the jobs, the abuse, and the horseplay?
I believe so. I think Dad had indicated that he had a better understanding of Caden's concerns.
And is it your perception of Caden's relationship with his dad that he still feels uncomfortable returning to his dad's home?
Yes.
As a professional, what are you suggesting would be in the best interest of Caden as it relates to his contact with his father?
I would suggest some weekend visits or some, 2 to 3 nights at a time to see if indeed the concerns that Caden had shared before, if those things have actually changed.
Did you discuss any difficulties that he was having with Mom?
I've asked him if he had any concerns about his house at Mom's, and he didn't mention any specific concerns about Mom.
Okay. Do you believe that your counseling with Dad and is at least at a positive point where it very well may get better with a longer period of time of counseling?
Yes, absolutely. I did share with both parents that they're both about 50 minutes from my office. And I think that is somewhat detrimental. Just it's hard for them to make appointments because of the distance.
All right. And are you willing to counseling with both parents and Caden as it would be required?
Both parents together or just both parents with Caden?
Whatever you wish. One parent with Caden and you, and then another time a different parent and Caden and you.
Yes, I would agree to that. I did have one session with dad and mom and Caden, and I didn't feel that that was beneficial.
Okay, all right. I have no further questions this time, Your Honor.
Okay. Ms. Greenlee-Clore?
Thank you. Ms. Briggs, did you ever discuss schooling and where the child had a preference of attending?
Yes, we did.
And what was the preference?
He was always a little torn. He said he likes his teachers in Battle Creek better, but he liked the students in Allegan better. When I said you can't have that, though, you got to pick one or the other. He has up until last week said he'd prefer to go to Battle Creek schools. Last week he flip-flopped that, and I was like, what's going on? Why the change? And my belief is that he's extremely scared of, as all my kids going into freshman year, the large building, getting lost, so many kids. He seemed very concerned about Battle Creek Central, but logistic concerns, which is very typical of somebody going into their freshman year.
And have you dealt at all with his school performance in Battle Creek schools, or is that not something you've touched?
I've touched as far as asking how his grades were, how he was doing, but I have not had any direct contact with the school.
Okay. When has so you stated before that previously his position had been that he wanted to stay with his preference had been to stay with mom. Has his position ever changed and said that he wants to go back to dad and dad's family?
Not fully, but when dad is with us on appointments, he tends to shift to what I feel like is what he thinks the adults want to hear. So he would talk about things in the context, oh, it'll be fun when I come home and we do this. But he's never said to me directly, I want to go back and live at dad's house. He's said the opposite.
And let me ask you this question. Since Caden has been with mom for a very significant period of time, over a year at this point in time, do you think that her influence on him during that period of time has shifted his desire or him stating that he wants to stay with mom?
No.
Okay. So you don't think that if he were staying with dad, he would say he would want to stay with dad?
No.
Okay. Even though when dad is in there with him in person, he says, oh, well, I want to go to dad's house.
Yes. So maybe I can explain what my rationale for that answer was. I felt like when I first met Caden in January, he was much more adamant that he did not want to go back to dad's house. As time has gone on, I feel like he's almost softened. So the opposite of like mom influenced him to not want to go, if that makes sense.
Okay, so his stance on that has kind of softened over time as you've been working with him to the point where he's now at the point where he would be okay going to dad's.
Yes, I think it's hard to say. He said before that he would be scared to go there because he feels like things haven't really changed or things won't be different. But then just last week when I met with him and dad, he was kind of like very softened of, okay, whatever the court decides I'm doing.
Were you informed or aware at any point in time that mother had prevented any contact whatsoever between dad and Caden for a significant period of time?
No.
Would that change your opinion about what Caden has been telling you? Say, let me expand on that. Say that she refused any sort of communication between May and December of 2023.
Yeah, I don't know. I do feel like when I first met Caden, he spoke of like being scared of dad more, he was more adamant about being scared with dad. So it's hard to say. I guess I would have had to have talked to him at that point, but certainly I always encourage both parents. Yes, I would always encourage that both parents continue to have contact with the child. So if one person is preventing that, that would not be in the child's best interest.
My question is, would that have influenced Caden, in your opinion, to say he wanted to stay with mom if he'd been with mom and been kept from dad for that long period of time?
No.
Okay. In your experience, would you consider this child abused? I can expand on that question if you'd like.
If you could expand on what your definition of abuse is, I would appreciate that.
Well, I'm not the expert on abuse, so I'm not going to define that, but we've had that term tossed around a lot, and you indicated in your testimony with Mr. Schaefer that Caden was defining abuse as this rough horseplay. Is that your understanding of the abuse that he's referencing, or that his mother is referencing?
Yes, I would say though that Caden talked to me about that there were bruises sometimes left, or like red marks because the wrestling had gotten out of control, or Dad would like jokingly kind of hit him on the back of the head. So Caden did indicate there were some red marks, and I think there was one incident where he said he was shoved to the ground and that left a bruise.
So when you say wrestling, is that between Dad and his brothers?
I believe it was between Dad and Caden.
Okay, and were you aware that Caden also has brothers in the household?
Yes.
Okay, and so, but your understanding is none of this happened with wrestling with his brothers. This is horseplay with Dad. Is that correct?
At least what Caden was referring to as abuse only happened with Dad. He never complained about wrestling. His brother is younger than him, though, so maybe he would have never gotten hurt in that type of a situation, but he never indicated he wrestled with the brother and that was an issue.
Okay. When you talked about, or have you talked about the pros and cons of living with each parent and what those might be?
Yes.
What kind of pros did Caden indicate would be at Mom's house?
He feels like the house is much quieter. I think there's less like little children in the house. So he does seem like a little bit of an introvert to me and likes, I think, things quiet. So probably the biggest, I would say, benefit would be, I think he's more comfortable in that setting and I think Mom is able to give him a lot of one-on-one attention because she doesn't have, I think she has one other older boy in the house, similar in age to Caden. And Caden would complain that Dad worked, till 8 p.m. at night and he didn't see Dad a lot.
Did Caden ever indicate that maybe a pro of living at Mom's home was that there were no chores and less discipline?
Not less discipline, less chores for sure.
Okay, so that's one of his reasonings for saying, hey, I want to stay at Mom's house?
Yes, I talked to him about that too, and the benefit of having chores and responsibilities, so.
And after talking to him, did his opinion on that change?
No, but I think his opinion on that changed when Dad and I met, and Dad said that they reviewed the chores he used to have, and they've decided that that was a little bit much. And so once he returns to Dad's house, he wouldn't have all the same chores.
Okay. Maybe I've already asked this, would Caden be okay returning to Dad's house to attend school in Allegan School District beginning in this fall, in your opinion?
I don't have concerns of like physical abuse if he returned to Dad's house in September. Is that answering the question?
That answers the question. Yes. Thank you. Okay. All right. And I have no further questions. Thank you.
Okay.
Thank you.
Mr. Schaefer, any redirect?
I don't believe so, Your Honor.
Okay. Ms. Briggs, that will conclude your testimony. Thank you very much. You're free to go. Have a wonderful day.
Thank you so much.
Obviously, we've concluded, I guess, at this point, unless there's anything else that I'm missing, we'll go into closing arguments. Mr. Schaefer?
Okay, thank you, Your Honor. Your Honor, you have before you a case where Caden, 14 years old, has been with my client since May of 2023. So a year and about 3 months, and has not been back to his dad's. Caden testified that he was fearful of going back to his dad's. He testified that he had been physically abused by his dad, and he was afraid to return to his home. You have heard that when this was expressed to his mom, she filed for an ex parte order to keep the child to go back to Dad's. It appears that the counselor has confirmed most of that which Caden has testified to, that he's still fearful of his dad's home. I think they're making progress. My client's position is that yes, he should have a relationship with his dad, but Caden is at a point that he has refused to go back to his dad's, and as a result of that, when he was returned on July 28th, he wouldn't get out of the car. There was time given for dad to talk to Caden, and Caden wouldn't stay with dad. We have heard that mom has pretty much solely supported the child for this 1 year and 3 months. We have heard that pursuant to the guidelines of the best interest, that there's a close relationship with Caden and mom. I think that the testimony is that he looks for her for the nurturing. We have heard that there's been no support financially or otherwise from the father in this last year and 3 months. My client has testified that she makes $17 an hour, that she has provided for the child all of the necessities of housing, food, and so forth, and she has the disposition to care for the child. I would submit that there is a established custodial relationship with mom, and the year and a half, I think, is sufficient to establish that, and that is an important part of the analysis in this particular matter. And I believe that everything that we have heard is that Caden doesn't want to go back to dad's now. The counselor says that she thinks she's making some progress, and perhaps this ought to be reviewed in a 3-6 month period to see what progress has been made. But the counselor says that her opinion is that he should not be returned to dad's home at this point in time. The testimony about the school, he is going as a freshman. The counselor indicates that he's having some apprehension of that. I don't think that is unusual. I think the mother has encouraged the child. There's nothing that I have heard that she isn't willing to facilitate the relationship with dad, and she is indicating that she would do so. I think under the best factors, especially the preference of the child, not only has the child told that to the counselor, has told it to the court, in court, in relation to his testimony. The impediments at dad's house is that apparently dad did not recognize the abuse that he was inflicting on his child, and he even indicated that he has taken another look at that, not only to the counselor, but to the court. In his testimony, he said that he has reviewed his behavior with the other children in his home and backed off of whatever he is doing. Caden indicated that his physical abuse was that he was getting hit in the head numerous times, almost daily, during this time period. So I don't think that is in dispute. And even his dad testified that, yeah, I went too far, and he says, yeah, there were times that I thumped him in the head, was his term. Dad has physically abused Caden. Dad does not have a driver's license. He's apparently a recovering alcoholic, as he had testified to, and has had difficulty of other children in his home. Right at the moment, Caden feels safe in mom's home, wants to stay there. He doesn't want to return to dad's home at this point in time. I would respectfully ask the court to take all that into consideration, grant physical custody of the child to his mom. I would ask that there be parenting time awarded to dad, and I think it ought to be on a graduated basis, as the counselor has suggested, and with an effort to repair whatever problems there are with this relationship. And I would respectfully ask that the counseling continue with the counselor, with both parents at her discretion as to when. She says there's being made, but she's saying Caden shouldn't be required to go back to his dad now. That is the request that we have based on the evidence. And obviously, I think that the support needs to be readdressed based on Your Honor's decision. My client has placed on the record of her earning ability of $17 an hour. I went through my notes and I don't know what the income of Mr. Roth is, but I would respectfully ask that that be disclosed for the purpose of support. That's our request, Your Honor. Thank you.
Thank you. Ms. Greenlee-Clark, go ahead.
Thank you, Your Honor. I want to be clear that the counselor's last testimony was she did not have any concerns about Caden returning to Dad's house. So I want to be very clear that that was the thing that what she said. To see what's happening in this case, you've got to go back in time. This has been going back in time until May of 2023. We have to look at the motion that was filed then, and the motion that was filed then was an ex parte motion to keep Caden with mom because dad was allegedly going to, quote, make the child speak to CPS and or the police regarding the alleged incident with the child at dad's house. That was the original reason. We went back and forth multiple times with this court. We made multiple appearances, and this court finally ordered that Caden then be returned to father in July of 2023. And only then, months into this, was when these alleged abuse allegations started coming out. Now, we just heard the counselor indicate that the alleged abuse apparently is roughhousing between dad and son. And dad himself has indicated, well, maybe sometimes this got a little bit rougher than it should have, or rougher than the minor child, who sounds like he's an introvert, may have wanted it to go. And father has acknowledged this and certainly has no intention of continuing any sort of contact that the minor child doesn't want. But I want to be very clear that these alleged abuse allegations were not there in the first place. It was only this alleged, my client making this child speak to CPS or the police. But then I want to be clear that then after these allegations came out, then mom herself had the child talk to CPS and talk to the police, even though that was her original reason for getting an ex parte order to keep the child in her care. In her care over the last year, she's kept the child from dad and kept the child from his other siblings and from his stepmother. She kept the child out of the last few weeks of school. The child didn't even go to school for the last few weeks. When she was ordered to take this child back to school in Allegan County in September of 2023, she didn't. She took the child to Battle Creek School. Not only that, but she didn't tell Mr. Roth. He had to call every school in Battle Creek to find out where that his child was even attending school. This is a situation that she's created on her own. It's a situation of her own creation. She has kept this child from his father, who legally has custody of the child, and has violated and fought this court at every turn, now for well over a year. At this point in time, it's time for Caden to go home. Caden's doing very poorly in school in Battle Creek and with mom. He was a straight A student in Allegan schools, and starting as a freshman next year, it's important for him to have good grades if he wants to have a good future. It's important for this child and in this child's best interest to go back with dad so that he can get the better grades he was getting. And I believe he indicated during his testimony that his grades were better with dad and that he had a better school performance with dad. And that's very important at this point in time. He's not doing well in school. This court will also recall that this court ordered mother to get the child in counseling, and she didn't do so until we had to come here again for this court to again order her to get this child into counseling. And again, that didn't even happen until January. So we're looking from May until January that this child wasn't in any sort of counseling. He wasn't talking to dad, wasn't having contact with dad. Mom had been ordered to return the child. She didn't do that. Mom had been ordered to take the child to Allegan schools. Didn't do that. She has violated almost every order this court has given, every single one of them. And after the last time she was supposed to return the child, she was supposed to turn herself in to the Calhoun County Sheriff to serve time in jail. She didn't do that either. So at this point in time, we believe that she should be held in contempt of court for all the multiple violations of court orders that she has done. We're asking that she be responsible for all of my client's actual attorney fees and costs in pursuing this matter over the last year and a half or so. And we're also asking that her motion be denied in its entirety, that the minor child be returned to father immediately so that he can attend school in Allegan County starting in the next year. The child can continue counseling with Ms. Briggs. That's fine. My client will continue counseling with Ms. Briggs if she deems that to be appropriate. And the front of the court can certainly undertake a modification of child support if this court deems it to be appropriate. But it's time for Caden to go home. It's time for Caden to go back to the house where he was being successful. He was a straight A student. He was happy and he was surrounded by his siblings. It is not time for this court to modify the parenting time or the custody order and put this child with mother. Mother has been in and out of this child's life, his entire life, and that is why father has sole physical custody of this child. Mother's disappeared for up to a year at a time. Father and his wife have had to ask mother to come back and see the child at some point in time. So of course this child is happy that he's now getting the attention he craves from his mother. He's never had that before. But at this point in time, it's time for this child to go home. We're asking, again, the motion be denied and that she be held in contempt for the multiple orders she's violated and also be responsible for my client's attorney fees and costs. Thank you.
Thank you. Mr. Schaefer, anything else?
Yes, it is clear from independent testimony and the counselor that Caden is still afraid to go back to his dad. They're making progress. It is clear that dad abused him physically, whether he thinks he was just a little over zealous in his horseplay, but there were bruises, there was thumping on the head, there was concern to the point that Caden was fearful of going. Caden was taken to his father. He'd go with his father. The testimony was that it was some 45 minutes to an hour that the father tried to convince him to go with him, and he would not go there. There is an established custodial environment with mom for a year and 3 months. And for that year and 3 months, mom has been the nurturing parent, the only nurturing parent that this child has had, and that should continue. That doesn't mean that dad cannot improve his relationship with the child and eventually obtain, parenting time and things of that sort. Comment about the CPS. This did start out with the father neglecting the well-being of his child by him saying that he was going to have the child talk to the police officer and the CPS in relation to charges against Caden. The second CPS was not that. The second CPS interview was the abuse by his father. And it was very important initially that this child be protected when police wanted to talk to him about allegedly abusing his little sister in the same house, which is still problematical if and when he goes back to that house on visitations or anything else. That is a concern of placing Caden back in that. And that's been kind of poo-pooed through this whole thing, which it was a significant issue at the beginning of this matter. The abuse allegations, as testified by my client, came later by the child. And when they came later, they were announced to the court, and that's where this has ended up. But the protection of the child initially was for the father failing to protect the child. Your Honor, there is a established custodial environment. I believe that the factors of the Child Custody Act favor the mother at this point in time. The child does not want to go back with his father now. He's a freshman in high school, and I'm not sure that's a good situation to have a child of that age in a home that he does not want to go back to. He was quite clear in his testimony before the court, and I respectfully ask the court to review that. I would renew my motion, Your Honor. Thank you.
Okay, thank you. Well, that concludes the trial or evidentiary hearing in this matter. What I'm going to do is, I didn't anticipate that we would be done this soon. What I'm going to do, though, is because we do have it set for Friday, and I did want the parties to be here in person when we have the ruling in this matter. So what I'll do is we'll adjourn until Friday at 8:30 and have everyone appear in person at that time. Anything else, Mr. Schaefer?
Nothing further, Your Honor. Thank you.
Ms. Greenlee-Core?
No, Your Honor.
Okay, we will see you all this Friday.